The courts, in exercising their discretion in matters of injunctions against Parliament, demonstrate a careful consideration of these principles, opting to intervene only when absolutely necessary and when the legal threshold for such interventions are unequivocally met. Honorable members, it's time for reflective conclusion. Several critical points emerge that underscore the importance of adhering to constitutional and legal frameworks within our democratic governance. Firstly, the President's refusal to accept the transmission of the bill is, by all accounts, not supported by the constitutional and statutory provisions that guide our legislative process. The Constitution clearly delineates the steps to be followed once a bill has been passed by Parliament, mandating the transmission of the bill to the President for assent or rejection. Therefore, the refusal to even accept the bill for consideration falls outside the legal bounds established by our constitutional framework. It is incumbent upon the President to accept the bill and take the necessary action within the prescribed constitutional limits, whether that action is assent, refusal, or referral to the Council of State for advice or Parliament for reconsideration. It is instructive to note that the Executive has in the past proceeded with its actions, although there has been pending before the court injunction applications against the state. Secondly, there must be a steadfast rejection of any attempts to unduly fetter or hinder the work of Parliament. The Parliament of Ghana operates as a crucial part of our democracy, embodying the will and voice of the people. Parliament embodies the sovereign will and power of the people. Parliament embodies the might and majesty of the people. And as I keep on saying, the power of the people is stronger than the people in power. Any efforts to obstruct its work, Parliament's work, disrespects this fundamental institution and threatens the principles of governance by consent and representation. Thirdly, it is imperative to remain vigilant against certain dangerous precedents that could potentially undermine the foundation of our democracy. The rejection of a bill's transmission without constitutional basis introduces a precarious deviation from established democratic practices and norms. Such actions, if left unchallenged, may embolden future attempts to circumvent the legislative process, thereby weakening the integrity and efficacy of our democratic institutions. Lastly, in alignment with our constitutional mandates and the principles of good governance, it is essential for the President to adhere to the lawful course of action by accepting the transmission of the bill, Upon receipt, the President has the constitutionally provided options as to what to do. I don't want to repeat it here. As we move forward, it is the collective responsibility of all branches of government, and indeed all citizens, to uphold the Constitution and ensure that our democratic processes are not only preserved, but strengthened. The current impasse presents an opportunity for reflection and reaffirmation of our commitment to the principle of democracy, rule of law, and the unequivocal respect for the legislative process that forms the bedrock of our nation's governance. Honorable members, the Parliament of Ghana will comply with the existing legal frameworks and reject the attempts by the Executive Secretary of the President through his contemptuous letter to instruct the Clerk to Parliament, an officer of Parliament whose position is recognizably under the Constitution. We shall not cease and desist. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson. Honorable member, I'm watching you. And I hear what you say. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson Nelson Eche K. Dafiamapo versus the Speaker of Parliament and the Attorney General, suit number J1/12/2024, which process was served on the 19th, that is yesterday, March 2024, and an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Honorable members, in the light of this process, the House is unable to continue to consider the nominations of His Excellency the President, to use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honorable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction. And that is enough to injunct Parliament from proceeding with the consideration of the business in the House. Honorable members, I thank you all for your attention, and may God bless our homeland, Ghana.
In case you're wondering why such a response from the Speaker, it is important for you to know that on Wednesday, February 28, 2024, the Parliament of Ghana passed the Promotion of Human Sexual Rights and Family Values Bill, widely known as the Anti-LGBTQ+ Bill. The bill prescribed lesbian, gay, bisexual, and transgender activities and criminalized their promotion, advocacy, and funding. On the 4th March 2024, President Akufo-Addo gave his response in regard to this bill, preventing Parliament from transmitting the bill to his desk. His excuse being he awaits response from the Supreme Court based on the challenge mounted at the Supreme Court by a concerned citizen.